Hi, Assalamualaikum. My name is Aisar bin Khalid Kamel and my metric number is DMM181006.
Hi, Assalamualaikum. My name is Shaidatul Nisa binti Azrul and my metric number is DBA181023.
Assalamualaikum, my name is Amirulloh. My metric number DBA182001.
My name is eikmal bin Juari. My metric number is 182010.
My name is Syafinaz, DMS 182001.
It's Muhd Azrul. My metric number is DBA182012.
Hi, my name is sofea binti Hazai and my metric number is DMS 182022.
Hi, my name is Megat and my metric number is DBA182009.
So, for voidable contract, the contract is legal agreement which binds the party to act in such a manner that meets the predetermined objective. Moreover, to make the contract legal and valid in the eyes of the law, then there should be free consent of both the party. In the absence of free consent, any contract becomes invalid in contract of the law. Most importantly, the court of law only admits the valid and legal contract. A person can knock the door of the court only in the contract is legal and valid. The voidable contract is a type of contract which is legal and valid. However, in case voidable contract, only one party can exercise the power of legally made. If one party reject the offer, then its contract become invalid and unlawful. Moreover, voidable is term typically used concerning a contract that is valid and binding unless voided or declared void by a party to the contract who is legitimately exercising a power to avoid the contractual obligation. The voidable contract is a type of formal agreement which is in between two parties. If there is absence of mutual consent, then it becomes an invalid contract. The voidable contract is a type of valid contract, an agreement which may become unenforceable in the contract of law by one party. If any one party denies accepting the term and condition of the contract, then the contract becomes voidable under the courts of law. In most of the case, is it seems that at the initial level the contract is valid, but becomes voidable due to the presence of misunderstanding, consents, and so on, which make the contract unenforceable under the courts of law by one party. In simple language, voidable contract is a short of formal understanding which is the middle of two gathering. On the off chance that there is missing of common essence at that point, it end up an invalid contract. The voidable contract is short of legally made contract and understanding which may end up unenforceable in the official courtroom by one of the gathering. A common situation that makes a contract voidable is fraud, misrepresentation, duress, mutual mistake, and undue influence. That's all from me. Thank you, madam.
I want to explain about effect, voidable contract and void contract. So, essential the difference between void and voidable contract is enforceability. A void contract is illegal and unenforceable. A voidable contract is legal and enforceable. So, for point void contract is a contract that is void is unenforceable, meaning that neither party has legal resource against the other for a breach. A contract can be void from the beginning or become void due to certain circumstances, including number 1 is it involves illegal activity, number 2 it is against public policy, number 3 it is impossible to perform, and number 4 it involves a party who is not legally competent. So a contract may be valid when it is executed but later become void due to change in the law or the circumstance of either party make fulfilling the contract impossible. Some issues will make a contract void on its face, meaning that the contract as written is void and cannot be amended to possible. Some issues will make a contract void on its face, meaning that the contract as written is void and cannot be amended to make it enforceable. So for voidable contracts, a voidable contract is a valid agreement between two parties, where usually only one of the parties is bound to the contract terms. A voidable contract can still perform under the law. However, one party has the option to cancel the contract if the contract has one or more legal defects such as fraud or misrepresentation, terms are unconscionable, duress or undue influence, and mutual mistake. So if defects are found in the contract, a party can reject it. If the contract is not rejected, it remains a voidable contract that can be ratified. When contract disputes arise, you need experienced legal representation and advice. Williams Mastaff LLP is a law firm focusing on commercial litigation and business divorce. So contact us at 23-256-9150 and schedule a time to meet with us today. Thank you.
Next question. The word caution is defined in 5.15 of CA 1950 as caution is committing or threatening to commit any act forbidden by the penal code, or the unlawful detaining or threatening to retain any property to the prejudice of any person, whatever with the intention of causing any person into an agreement. So the explanation is, it is immaterial whether the penal code is or is not enforced in the place where the caution is employed. And this is some illustration about caution. So first, A on board an English ship on the high seas cause B to enter into an agreement by an act amounting to criminal intimidation under the penal code. Second, A afterward sues B for breach of contract of typing, and last is A has employed coercion although his act is not an offence by the law of England, although 506 of the penal code was not in force at the time, one or place where the act was done. Like an example of Mutu v Mutu Karupa, an agent refused to hand over the account books of a business to the new agent unless the principal released him from all liabilities. The principal had to release the deed as demand. Held the release deed was given under caution and was at the option of the principal. The second case is Kesama SO Lakshman Das v Kaliapan Cetiapa. It was held that a transfer of execute under orders of the Sultan issued is the ominous presence of two Japanese officers during the Japanese occupation of Malaya was invalid. The court held that consent was freely not given and the agreement was voidable at the will or option of the party whose consent was so caused. So the issue is strict to commit suicide caution. Madras High Court held by majority judgment that even a treatment to commit suicide is caution even though it is not punishable under the Indian Penal Code. So the example, a man by giving a threat to commit suicide induced his wife and son to execute a deed in favor of him in respect of certain property, and they execute, held that the consent of the wife and son has obtained through caution. The effect of caution is when the consent of the party to agreement is obtained by caution, the contract becomes voidable at the option of the party whose consent is so obtained. So that's all for me.
So today I want to talk about undue influence. So the undue influence is the doctrine of undue influence. It's a development of equity to cover cases of particular relation and is sometimes used a comprehensive phrase to include case of coercion, domination, or pressure within or without those special relation. The doctrine as embodied in S.16 of CA 1950 is in substance based of English principles. 5.16 reads. Okay, so the first point is, a contract is said to be introduced by undue influence where the relations subsisting between the parties are such that one of the parties is in position to dominate the will of the other and use that position to obtain an unfair advantage over the other. Okay, so the second one is, in particular and without prejudice to the generality of the foregoing principle, a person is deemed to be in a position to dominate the will of another. So, the point is, where he holds a real or apparent authority over the other, or where he stands in a fiduciary relation to the other. Where he makes a contract with a person whose mental capacity is temporarily or permanently affected by reason of age, illness, or mental. Okay, so next is where a person who is in a position to dominate the will of another enters into a contract with him, and the transaction appears on the face of it or on the evidence adduced to be unconscionable. The burden of proving that the contract was not induced by undue influence shall lie upon the person in a position to dominate the will of the other. Okay, so the illustration is, a man enfeebled by disease or age is induced by B's influence over him as his medical attendant to agree to pay B an unreasonable sum for his professional service. So the point is, the relations subsisting between the parties are such that one of the parties is in the position to dominate the will of other. You use that position to obtain an unfair advantage of the other. And then the following are the parties that can be affected by undue influence. Okay, doctor and patient, teacher and student, lawyer and client, and also trustee and beneficiary. Okay, so Rosli Darus, Vimanso, Haji Sa'ad and Ano. The High Court gave judgment for the plaintiff. In this case, the plaintiff had pleaded that the transfer of his land to the defendant was null and void as the defendant had exercised undue influence over the plaintiff. Here the defendant were the plaintiff's uncles, and one of them had by conduct put himself in loco parentis whilst the plaintiff was young and orphan being the adopted son of the defendant's late sister. When declaring the memorandum of transfer of the land null and void, the High Court reiterated that the equitable doctrine of undue influence means that there subsisted a relationship of trust and confidence or dominance over the other party and derive some benefit from him. That's all. Thank you.
I would like to present about voidable or fraud. Okay, fraud means and includes of the following acts committed by a party to contract or to induce him to enter into the contract. And then first is the suggestion as to a fact of that which is not true by one who does not believe it to be true. Second, the active concealment of a fact by one having knowledge or belief of the fact. Third, a promise made without any intention of performing it. And the last one, the meaning of fraud is any other act filtered to deceive. The definition of fraud, which is a false representation willfully made by a party to contract in order to mislead the other party and inducing him to enter into contract, is known as fraud. Example is A purchased goods of 5,000 from a shopkeeper B, and then with the intent of not paying the money to B, this type of act amounts to fraud. Okay, next, essential of fraud. First, there must be a representation and it must be false. Second, the representation must relate to the material fact. Third, the representation must have been made before the conclusion of the contract with the intention of inducing the other party to act upon it. And the last one, the other party must have been induced to act upon the representation. Okay, I have other two examples of fraud. The first one is Manage was induced to be shares in a company on account of a false statement made by a stranger. It was held that he could not get out of the bargains because false statement was not made by the company or its agent. The second one is Manage says to Debika his coat is made of pure wool, even though he knows that it is untrue. Debika purchased the coat believing Menard's statement to be true. It is a fraud by Menard and therefore contract is voidable at Depica's option. The last point is effect of fraud. Section 19. The party whose consent to the contract is obtained by fraud can exercise any of the following rights, which is he may avoid the contract and may ask for the damage suffered because of the non-fulfillment of the contract, and he may insist for the performance of the contract.
Okay, next I will explain about misrepresentation in law. In common law, misrepresentation is an untrue or misleading statement or fake made during a negotiation by one party to another, the statement that make another party to enter into a contract. The misleading party may normally resign the contract and sometimes may be awarded damage as well. A representation is a pre-contractual statement made during negotiation. If a representation has been incorporated into a contract as a term, then they normally remain the branch of the contract apply. Okay, I will explain about what is misrepresentation. Misrepresentation is the positive assertion in a manner not warranted in the formation of the person making of that which not true, through be believed it to be true, causing, however, innocently a party to an agreement to make a mistake as the substance of the thing which is the subject of the agreement. Misrepresentation is a false representation made innocently without any intention of deceiving to the another party. It may include two things: wrong statement of the material fact not known to be false, non-disclosure of fact where there is a legal duty to disclose without intention to deceive. Okay. Like this example, Sim tong reality senyar berhad V Teh Kim dat A Teh Kim in 2003, the court took the position that the victim of an innocent misrepresentation is not be put in exactly the same position as if the representation had never been made. Damage, instead, the representer be returned to his position only so far the regard the right and obligation which have been created by the contract into which he was induced to enter. Okay, based on the case, there is clear distinction in a grandly relief misrepresentation made fraudulently and those made innocently. This reflects the equitable nature of right to decision and administer justice based on the factual matrix of each case. Okay, for the conclusion, is with the option of resigning and claiming for damage in the event of fraudulent misrepresentation. It is for the victim corporation to make a business decision whether to proceed with the just course of action by considering the evidence available as well as the amount of the damage and claimable. Thank you. That's all from me.
And today I'll be explaining about mistake in contract law. A mistake in contract law is an error understanding facts, meaning of words or the law which cause one party or both party to enter into a contract without understanding the responsibility or outcomes, such as mistake can entitle one party or both party to a restriction cancellation. It means a mistaken understanding of the law as distinct from facts by one party only is usually no basic for rescission, since its ignorance of the law is no excuse. The second one is mistake covers a broad set of situation, and court often distinguish between unliteral mistake and mutual mistake. Unliteral mistake is an incorrect belief of one party that is not shared by other party. Mutual mistake is an incorrect belief shared by both parties. Court have traditionally held that mutual mistake are more likely than unliteral mistake to make a contract viable. Thank you.
So for the conclusion is where dispute arises regarding the status of void contracts, courts may declare voidness of the contracts. It is to be noted that declaratory judgment of voidness may be given at any time without the need to comply with the requirement of period of limitations. Declaratory judgment of voidness cannot be stale, and passage of time cannot cleanse the defect that vitiated the contract. As a void contract is an act inexistent in eyes of law. It is apparently imprescriptible. This is so as opposed to voidable contracts where an option in invalidate the contract should be exercised within 2 years from the date of disappearance of cause rendering the contract defective. It must meanwhile be noted that the right to demand invalidation of the voidable contract cannot go beyond the maximum period of limitation that is investigated in Article 1845 of the Civil Code. After lapse of 10 years, maximum period of limitation that is investigated in Article 1845 of the Civil Code. After lapse of 10 years from the formation of the contract, the defect is presumed to have been cleansed by operation of the law. However, the court may void agreement due to the ground of defective object and form. With voidable contract, defective due to lessened capacity of defective consent, as a result of which ambiguities and contradiction arise. This apparent contradiction between Article